Final case on the docket is City of Jacksonville versus Cofield. Cofield, I think. Cofield. Counsel for the city.
Good morning. May it please the court? Counsel? Good morning. My name is Dylan Reingold. I'm here on behalf of the appellant, the City of Jacksonville, and I'd like to reserve 5 minutes for rebuttal. The city is here requesting a reversal of the trial court's decision holding the city liable under Section 70.001 of the Florida statutes, the Burt J. Harris Act, for the closure of the Windsong Place right-of-way. This is a decision that actually has implications not only on the City of Jacksonville, but I believe upon many local governments within the state of Florida. Specifically, what the court has found is that the court is holding the city as the guarantor of the risks and the gambles that are taken by land developers in their land development deals. And if you look at the background of this case, in January of 2006, Mr. Cofield signs a purchase and sale contract for a piece of property located adjacent to Windsong Place. Soon thereafter, within days, the neighboring property owners to the west of Windsong Place file an application with the City of Jacksonville for the closure of Windsong Place. And at that time, Mr. Cofield is notified of this application pending before the City of Jacksonville. In April of 2006, an ordinance is brought to the City Council of the City of Jacksonville, which proposes to actually close the right-of-way. And after extensions of time, Mr. Cofield in June closes on the property and obtains title. In August of 2006 is when the City Council of the City of Jacksonville actually finally closes the Windsong Place right-of-way. The important aspect of this history is the fact that there are two processes going on at the same time. Mr. Cofield is going through his due diligence and has extended the time of his due diligence, while at the same time the City of Jacksonville is processing an application to close the right-of-way, and then furthermore is considering the ordinance that is pending before the City of Jacksonville. At this point, the gamble that Mr. Cofield is taking is either A, the City of Jacksonville won't close the right-of-way and I'll get my 8-unit subdivision, or B, if the City of Jacksonville closes it, well then I can go sue the city for my damages. Thus, there is no gamble for Mr. Cofield. He doesn't have to consider the implications in his investment-backed expectations of his closing on the property.
Wasn't there testimony also that he thought that even if the city enacted the ordinance, the effect would be to remove the easement? He, as the abutting landowner, would get half the formerly public roadway, and with that could give access sufficient to these 8 lots that get the driveway permits and so forth.
Well, Judge Benton, there are two aspects of that. First off, the ordinance itself had actually proposed to close the right-of-way and have the homeowners association to the west maintain it, and that was clear in the ordinance. Additionally, there's a key aspect, and this issue is brought up.
I'm not saying that his expectation was reflected a correct understanding of the law, but I'm saying was there not a miscalculation on his part based on his misunderstanding of the legal effect?
Judge Benton, there was a miscalculation on his part. You're absolutely right. And actually in the Campidi case, the court in that case talks about how an example where a developer felt where they had gone through a title search, found a document that had granted some riparian rights to a previous owner of that property, stating that they essentially leading that developer to believe that they wouldn't have a problem with the Army Corps of Engineers having jurisdiction over the wetlands on his property. He inappropriately or incorrectly made an assumption of the law, which is what Mr. Cofield did here, and the court in that decision said, look, we're not going to hold the Army Corps of Engineers to serve as the guarantor of your gamble. Mr. Cofield took a gamble. He made an assumption that half the property would come back, or half the easement would come back into his possession, and now he wants the city of Jacksonville to essentially guarantee that gamble.
Does it matter, or is it true that if he had acted on the knowledge that he had back in February, that he would have forfeited his binder?
At the beginning, actually, he had 60 days to have his $25,000 returned. But the issue really goes...
So when he learned of an application, that an application had been made to close the right-of-way, he could have walked away with all his money.
Yes, Your Honor.
Up to 60 days.
Yes.
So there's no forfeiture until after 60 days. He knew about this at some point in, what, like mid-February or?
Yes, I believe February 15th in the record is the date that he knew, or at least some point soon, two or 3 weeks after the purchase and sale contract. And that really leads to the issue of his reasonable investment-backed expectations. And the Oregon Supreme Court in Dodd talks about a property owner who was considering they were considering the reasonable investment-backed expectations of a property owner. In that case, when there was a pending zoning ordinance before that jurisdiction, in which the property owner has essentially known about the fact that there were going to be zoning limitations coming through on this pending ordinance, which is exactly the scenario here. Mr. Cofield was well aware that there was a pending ordinance to close the right-of-way, shutting off his access, and yet the Oregon Supreme Court in the Dodd case said, if you knew about it, even if you had constructive notice of this zoning limitation coming down through being passed by the government, you have no reasonable investment-backed expectation. And that's exactly what happened here. And reasonable investment-backed expectation is a critical component of what is considered an inordinate burden. It's defined under the Florida statute, section 70.001, as what is your reasonable investment-backed expectations of the existing use or the vested rights of the uses that you have on your property, in addition to the problems that are raised.
He also testified he thought the application would not be granted, right?
Well, Your Honor, the basis of that is peculiar in the record, and I find no substantial competent evidence to justify that the action would not be taken. The only evidence that is actually provided in the record is, one, a comment by a staff member from the Planning and Development Department raising some objections, as under our ordinance code, section 744.104 states that the ordinance to close the right-of-way can't even come to council until all of the agency's concerns are resolved. So that reliance on that statement by a Planning Department member does not hold any weight. Additionally, they rely upon a concurrency reservation certificate, which Mr. Cofield acknowledges is just the first step in the process. It only holds concurrency or capacity available for the property. It has nothing to do with the right-of-way closure. And finally, there's the letter from Mr. Sands on the record that states, at this time, driveway connection permits can be obtained if you undertake the applications, if you bond, if you have associated costs. There are clear indications to the applicant you still need to sort of take some additional measures before you have the rights to your driveway connection permits. And then finally, Mr. Cofield relied upon, as Judge Benton was pointing out, was the incorrect legal analysis of I thought half the road was going to come to me, and I didn't think the deed restrictions would allow the homeowners association to maintain the right-of-way. All of these items that I've talked about are essentially lower staff decisions. They are not the zoning authority. They are not the city council. They are not the mayor's office speaking on behalf of the city of Jacksonville. And I think it's inappropriate and I don't think any of those can stand as substantial competent evidence to serve as a vested right in this case. The courts in the state of Florida have talked about mere purchasing the property does not give you a vested right. Mere applications does not give you a vested right. Mere mere existence of the rights at that time don't grant a vested right.
Would you agree that if all this had occurred, by all this, I mean the petition of the Homeowners Association, the city's action, if that all occurred after the expiration of his due diligence, that he would have had a vested right?
Not necessarily, Your Honor. And the reason I make that statement is the courts talk about even rights at the time that exist do not necessarily equate to the equitable estoppel principles, which are the basis for vested rights under Section 70.001 of the Florida statutes. And the cases that actually are cited by Mr. Cofield, the appellee, specifically talk about a sort of bait and switch. In the Town of Largo case, the city or the town specifically knew that if they rezoned the property, the developer was going to purchase the property, and then after they rezoned the property, the developer purchased the property, and then they said, nope, we're going to yank that zoning away. There were some granting of some rights, there was some taking away of rights. And the instant case, there was really no initial granting of rights to Mr. Cofield. There was a public right-of-way. It existed. There were no promises that the city of Jacksonville was going to provide one. And then they later closed on the property. I see I'm now in the yellow zone. I would like to reserve some time for rebuttal unless there are some additional questions at this time.
Thank you.
Thank you very much.
Your Honors, my name is Jeb Branham. I'm here on behalf of the appellees Winsong Place and Harold Cofield. If it pleases the court, I think there's two main points that I need to start off with making. Number one, the city is not so much pointing out a lack of evidence in the record as they are saying we disagree with the conclusions that the trial court drew from the evidence that it saw at trial. The main issues in this case are fact issues, and of course we're here on a competent substantial evidence inquiry. The second...
Is there a standing issue in this case?
A standing issue has been raised. I don't believe there's a standing issue. I think it's very clearly addressed by the case law as well as the intent of the legislature. The two plaintiffs are Harold Cofield, the individual, and Winsong Place, LLC, a wholly owned limited liability company that he conveyed the property to after the governmental actions at issue. The case of Equity Resources versus Leon County, and that's in the context of an equitable estoppel case, says that a wholly owned entity can take advantage of the individual who owns its acts of reliance. Then if you get back into Clegg, which is an eminent domain case, it says that in an eminent domain case, the party that incurs the damages or owns the property when the governmental action is taken is the party that has the cause of action and can pursue it in court for damages, regardless of whether they divest the property later. You combine those two cases with the intent of the legislature, which is to compensate landowners for unfair effects of new laws, rules, and regulations, then I think it's clear that there is at least one, if not two, proper plaintiffs withstanding in this case. The city's argument is essentially, because the individual conveyed to a wholly owned entity, then therefore they can't be sued. I don't think that's the intent of the legislature. I don't think that's consistent with the law of the state. Did I answer your question adequately?
Yes, you did.
The other point that I think that the city is not addressed, and quite frankly, I don't believe I addressed it as adequately as I should have in my brief. If we go back at 70.001 and look at the legislative intent of the Burt-Harris Act, it says that it is the intent of the legislature that is a separate and distinct cause of action from the law of takings. The legislature herein provides for relief, payment of compensation, when a new law, rule, regulation, or ordinance of the state or a political entity of the state, as applied, unfairly affects real property. A new ordinance. The law that the city of Jacksonville was relying on is zoning law. To some extent, it's law of equitable estoppel. It is true that there is zoning case law out there that says that developers have to be aware of changes in the law. It is not correct to say that possession of a building permit is a condition precedent. The Burt-Harris Act, the legislature has said it is our intent to provide compensation to landowners when new ordinances unfairly affect your real property. I would submit to the court that this legislative intent and the enactment of this act actually changes the whole playing field that we're on. And you have to look at any law that says changes in the law are taken at your own risk with a great deal of caution.
You mentioned in your introductory remark that the judge's finding or your position is supported by competent substantial evidence. So I guess the first question we might be interested in is whether the statutory citation to the phrase inordinately burdens is subject to review de novo, or is it up to the finder of fact? And let me be a little more specific. Would we analogize there to the way we would renew a final order of inverse condemnation in terms of whether a taking has occurred or not?
Well, I've not done much, if any, eminent domain work, so I really don't know the standard of review in that circumstance.
You can leave that last part out then, because I think that becomes important. If inordinately burdens is a question of fact, that may help you quite a bit.
Sure,
If it's
and
a
I think
question
it
of
is.
law, it may cut the other way a little bit, so we need to know.
What I would urge the court to do is to look at the definition of inordinate burden in the statute. And it says the terms inordinate burden or inordinately burden mean that an action of one or more governmental entities has directly restricted or limited the use of real property such that the property owner is permanently unable to attain the reasonable investment-backed expectation for the existing use or vested right. The questions of reasonable conduct are questions of fact, and cite a number of cases from the First District and the Supreme Court in the brief. I would submit that the statute itself answers the question. You're looking at, is the investment-backed expectation reasonable? So you're automatically in a framework of, was the property owner's conduct reasonable, which is a fact question. The way that the city has approached the issue, they've attacked it as a fact question. They said it was unreasonable for him to proceed with this development. They have not made an argument in their brief that it's a legal question. The principal fact that I find them hanging their hat on, or the first fact, was that as soon as Mr. Cofield learned about the specter of this road closure application out there, it was then his duty to try to get out of the development. And I do want to clarify something for the court. The city has characterized his pre-closing period as a free look period. That's not what it is in the contract. It's certainly arguable that he may have been able to get out, but the contract itself, and the court will give me a moment, I'll read the exact language. What the contract says is, buyer will, at buyer's expense and within 60 days from the effective date, study, determine whether the property is suitable in buyer's sole and absolute discretion for residential single-family use. You've got two things, two competing interests. Residential single-family use, which the property was still eligible for after the enactment of this ordinance and after the city applied it to take away the right to connect to Winsong Place. It was still able to be used as a residential single-family lot. That's competing against sole and absolute discretion. So what the city's really saying is that as soon as Mr. Cofield learned about a mere application to abandon the roadway, it was his duty to go back to his seller and say, I want to get out. And he had already paid the $25,000. He may have been able to get out. He may not have been able to get out.
Sole and absolute discretion.
Yes, for use as single-family residence.
But doesn't that give him doesn't that put him in the driver's seat?
It may. It may put him in the driver's seat. It may not. The point is he has to take the risk. The city's saying, Mr. Cofield, when you learned about the application, it was your duty to try to get out, as opposed to his other choice, which was, I'll trust the city to do what's right, what's fair, what's lawful, and what's equitable. He chose the latter course of action. He testified at trial that he didn't think the road closure application would ever be granted. He also testified at trial that he didn't view the contract as giving him a blanket out, that it did involve some risk to him.
He testified he didn't think the application would be granted.
Yes.
And that even if it were, he had access that would suffice for getting the driveway permits.
Correct.
And both of those proved to be mistaken assumptions.
Well, I would...
Is the city responsible?
I would
for that?
respectfully disagree that those assumptions are mistaken, and we also have to, we're on a review of a trial, of a bench trial, and we have to look at what evidence was presented at the trial. The first assumption, or I would call it a result of his investigation, that the city wouldn't pass it in the first place, was the evidence is in the record from which you can infer that the city's goal was to give away this piece of roadway to stop his development. That's really not a lawful use of the power to give away roadways. It's a development that's otherwise permissible under existing zoning, and the city worked out this backroom way to stop it. So it really, he didn't think they would pass it, and it was testified to that. Under Florida Statute 336.12,
but there was also testimony that these applications are invariably granted.
Well, let me address that testimony as well. What George Paul, who's the head of the department who handles these applications, said was that ordinary road closures are granted as a matter of course. What he also said was this is the first closure that he had handled ever that dealt with gating a road with giving away a road so a subdivision could gate it. There's also no evidence that Mr. Cofield knew any of that. The city said he was on constructive knowledge, but that's just something they say in their brief. There's no evidence was adduced at trial that he should have known, that he was on a duty of inquiry. But the more important point was this is the first application like this the city had handled. Additionally, 336.12 says if you're talking about giving away a road so that a subdivision can gate it, there's a whole list of prerequisites. And Mr. Cofield testified that he looked at the statute, did some inquiry, found out that the Homeowners Association was too small to modify its covenants and restrictions to qualify to receive the road for purposes of gating. That contention was never rebutted at trial, and it was never rebutted in the city's briefs. It's an unrebutted contention. Additionally, I think it's very important to point out that as far as the belief that Mr. Cofield would get half of the roadway, George Paul, the chief of the department that handles roadway closures, testified that he shared that belief. So as far as what would happen if it was closed to the fee in the roadway, two people testified. They both said he would have half of it. The issue of whether or not he would not was not tried. That was an issue raised for the first time by the city in their brief, that the fee would not go to him. That was not an issue at trial, and there's no evidence in the record as to what would happen to the fee if the roadway were given away, other than the testimony of Mr. Cofield and the city's own official, George Paul, who said, I think Paul's exact words, they would have at least a piece of it coming to them.
So we still don't know the legal effect of the city's having abandoned the right-of-way?
I don't think we do. The city, in its
So
September 25th...
It may be that half of what had been the public road is now in your client's ownership?
It's possible, yes.
And so he may be able to construct these houses because he can get to driveway cutoffs that way.
No, he can't. And that gets into the second governmental action at issue, which is the September 25th, 2006 letter from Michael Sands that said, your development cannot go forward unless and until you provide proof to the city that you have access to Winsong Place. I believe Sherry Clayton, she's an officer at the Winsong Place subdivision, said the access would not be granted. So the city took the ordinance. And I will say for the record, I believe the city's interpretation of the ordinance is that it gave the roadway to the Homeowners Association entirely. And indeed, they applied it that way. So his development's dead in the water in the eyes of the city. He can't go in and get any more development approvals. They're not going to give them to him. I will say that's something that the city could have looked at during the process of negotiating a resolution that is supposed to occur pre-suit, but the city never bothered to engage in that process required by law. So we were brought here in this litigation context.
That's not a point on appeal, is it?
No, it is not a point on appeal. But it's important to the question you raised of how did we get here and why didn't we look at things like that? Because the city just ignored that part of the law.
Speaking of how did you get here, if you had gotten the driveway permits, then maybe you would have had a vested right.
Well, I believe we have a vested right, as the Burt-Harris Act defines a vested right anyway, and that's what the trial court found. But certainly, if we had the driveway permits, we certainly would have had a vested right. Now, we already have one now, as the trial court found.
All right, so what is the basis on which you say you have a vested right? Is that the part of the definition you're depending on, the vested right part? What
The trial court found, there were two actions that inordinately burdened Mr. Cofield's property. The enactment of Ordinance 2006-407 and the application of that ordinance to his property to stop his development through the September 25, 2006 letter. So those are the two actions. He found that both of those actions, either taken separately or together, inordinately burdened both existing uses of the property and a vested right to a specific use. The vested right to a specific use was the ability to convert the property into an 8-unit subdivision. Existing use is actually defined very interestingly under the statute. It's both a present activity and a reasonably foreseeable non-speculative land use that increases the fair market value of the property. And I believe you qualify under either prong of that definition as well, because there was the actual activity on the property of turning it into a subdivision. The testimony showed Mr. Cofield was undergoing activity, spent about $20,000 moving dirt, clearing land, activities like that. Also, the City of Jacksonville's own property appraiser found that the enactment of this ordinance and the loss of the resulting rights to Winsong Place devalued the property by $239,000. So you've got evidence in the record that the use was reasonably foreseeable and the use of being able to turn the property into a subdivision was reasonably foreseeable and resulted in an increased market value. So you've essentially got 3 or 4 different ways that the trial court can be right, and I would submit that they're all factual issues.
Thank you.
The trial judge felt like this was an abuse of the machinery of city government, didn't he?
I think what happened at trial, Your Honor, was I think the judge misconstrued some of the, and I'll not use this in a legal sense, the actions taken by some of the city employees served as actual acts by the government of the city of Jacksonville. And I think that's a really critical component of looking.
But he thought it was fundamentally unfair that the ordinance was adopted.
Your Honor, that is correct. The judge deemed the actions of the city unfair. What's interesting is that, and I was talking about this in my opening, was the judge talks about this welcome mat, the case law that talks about you can't set out the welcome mat for a developer and then yank it away from them. In those cases, in all of them cited by the appellee, it talks about cases where a building permit was issued, and then the city and construction started, and then the city took away those building permits. Or in another case where...
But the cases are clear, you don't have to actually have a building permit, right?
There's some question as to whether but you do need an act. And I would say in the case law that we've cited to, and the case law that I've discovered is that mere purchase of the property, mere applications for an application don't rise to the level of a vested right. And in fact, some of the cases talk about even having a building permit is not a vested right. And one of the concepts we were talking about vested rights was the developer's good faith reliance on a government act and then their substantial change in circumstances. The city argues is that there was no good faith reliance by the developer. The developer knew the application was pending. The developer knew that the ordinance was then pending in April. And then they simply decided to rely on certain issues pending before them, but turning a blind eye toward the actions that the city council of the city of Jacksonville was considering. And as I believe it was Judge Benton talked about, that had the developer in the driver's seat at that point. And the argument that was made by appellee was, well, at that point, the city is saying we had a duty to close on the property. The city isn't saying they had a duty to close on the property. The city is arguing when you knew about the road closure potential, you knew about the ordinance pending before city council, you at that point did not have a reasonable investment-backed expectation that you would get an 8-unit subdivision. And that, like, as I talked about in the Dodd case out of Oregon, said once you know about the pending ordinance coming down and limiting your use, you really don't have a reasonable investment-backed expectation. Also, one of the comments made by the appellee was that it was converting to an 8-unit subdivision. There was no real existing use of the property as required. There was no vested use. There was no existing use. There is no subdivision on the property. There are no final...
Well, existing use is defined very broadly by the statute, right?
Well, Your Honor, the existing use is the actual use or activity on the real property. The activity on the real property was there was some land clearing, which was...
Isn't that the reasonable investment-backed expectations language? Isn't that part of the definition of existing use?
Actually, existing use is defined in the definitions portions. When you go to inordinate burdens, it talks about in 70.001 that there needs to be a reasonable investment-backed expectations of the vested rights or the existing use on the property. And the existing use, the activity, the only activity is a land clearing. There's no subdivision, there is no construction, there is no final plat.
The land clearing comes long after word reaches Mr. Cofield about the possibility of the ordinance.
I'm sorry, Your Honor.
He learns about the ordinance. He doesn't know the property when he learns about the ordinance.
He has had a purchase and sale contract on it. That's all he's got when he hears about the ordinance coming through, and actually when he hears about the application.
Which I assume he's not out there clearing land before he acquires the property.
Actually, if I may answer the question, he actually started clearing the land during the purchase and sale period.
Do we know when in the record?
I believe he started doing it in January and February.
All right. The contract was signed in February?
The contract was signed, I believe, on January 24th or 25th, Your Honor.
And he immediately started clearing?
And he started clearing.
Is there any evidence in the record, whether you accept it or not, that the city or the city in conjunction with the Homeowners Association was motivated, at least in part, to prevent development of this property to the west of Winsong Place?
Judge Kahn, the neighboring Homeowners Association may have had the goal or intention of cutting off the development or stopping the development. Their application to the city states that they were seeking a gated community, a gated private roadway. The city of Jacksonville, and I've not seen on the record, had its own intention of cutting off the development. Thank you very much.